Let me talk a little bit about federal estate tax, which is going to be a major issue in all of this. Federal estate tax has been greatly modified in the last 10 years, and it's a tax right now that's at 45%, but it's slated to change. Federal estate taxes run, there's a unified credit that's applicable to each estate holder. It's a certain amount of credit that's subtracted from the actual tax. We can translate that or calculate that backwards through the federal estate tax tables, and it equates to a certain amount of property. And up until to the end of 2010, that amount's going to be $3.5 million that can be left behind. At the end of 2010, right now it's slated that we'll have a 12-month period with no tax, no estate tax, and then we'll go back to the $1 million exemption. And the result of that is that the taxes are going to be somewhere between 45 and 55% on every dollar that's exposed over and beyond those credits. That's a pretty huge tax. It grows very quickly. And most of those taxes, if we sit down and do some planning, we can probably eliminate 95, if not 100% of those federal estate taxes by implementing various types of planning devices. And it's critical to the survival of the business to get rid of that kind of expense, as well as being assured that we have good, competent management to survive the estate holder. In addition, there are different state death taxes. Florida right now does not have a federal state death tax, but there are, we still need to be mindful and careful of that. A lot of people in Florida will own assets in other places. And if you are in a state that has a death tax, there are approximately about 40-some states, 35, 40 states, that have either an estate tax on the total amount of the estate left behind, or they have their own inheritance taxes, and they have to be computed. If an individual submits data to our planning group, to foster estate planning, we can do individual state death tax calculations for the particular estate. And then the last expense to the estate is going to be probate administration. That's attorney fees. And no matter where in the United States you're located, if you leave your assets through a will or have no planning at all and they transfer through intestate, your assets still have to go through a probate process. It'll be mandatory. And there's a misconception amongst lay people out there, it's very popular, that you don't need to use a trust if your estate is small. And fact of the matter is probably the second largest expense to estates that are under those unified credit amounts are the probate attorney fees to have all those assets taken through court and retitled in the name of the heirs. Those expenses, along with funeral expenses, are really an important factor in doing some efficiency planning, reducing the estate costs for those smaller estates. So that's part of the issues that we're going to be looking at here with this large estate. I also have up here now a slide that shows the flow on the son. The son, you recall in our data, had a $735,000 estate. When he passes, he's got a second spouse, and if he leaves a simple will that says, "My dear, I love you so much, I'm leaving you everything I own," the problem with that is that there's a lot of needs that that's not really going to take care of. There won't be any federal estate taxes on that estate if he leaves it all to his spouse, but when the spouse dies, we have all sorts of problems. We're going to have a federal, we may not have federal taxes, but we're going to have probate expenses. The assets are not going to necessarily be going to the son of our estate holder's grandchildren, so the business doesn't necessarily descend down. Instead, that share of the family business would end up with the spouse, and then if that spouse has their own children, if it's a blended family and we haven't done proper planning, it ends up in their hands. So, and that can be a very expensive proposition, again, with a lot of different kinds of problems in our planning process. What I'm suggesting here is that this estate needs living trusts. Both the large estate holder needs a living trust and the son needs a living trust. A living trust is an entity that lawyers created on paper, and it was created several centuries ago in England. It's not something we can see or smell or feel or hold in our hands. It's something lawyers create on a piece of paper called a trust agreement. And in that, they appoint what's called a settlor or trustor, and that's basically the estate holder and probably their spouse. They're also going to be appointed as trustees. The trustees of a trust manage the trust, very similar to the president of a corporation manages a corporation. But this trust is going to be a legal entity that owns assets, and it'll have legal documentation, and it'll have provisions in it that read very much like a will. In other words, it's going to provide that when the settlor dies, it'll have provisions on how these assets are to be distributed. And in those provisions for distribution, the estate holder can write their own terms and conditions. They can leave it equally to 4 kids, but if somebody's disabled, they can put special provisions in there to control that share, avoid that person having control of their principal and even their income, so that it's not counted in disqualifying them from state and federal assistance. It's used by appointed trustees for that person's assistance and to supplement their living during their lifetime. If somebody's addicted to chemical drugs, again, the funds can be held by a trustee, managed by a trustee, and they can be used for that person's benefit without that person having control of the assets. If we have a business member, a son who's involved in the business, we can design the trust so that they either can acquire as much of the business as possible, and what they don't acquire, they would have the right to either purchase or to control, so the business doesn't collapse because of mismanagement. The great thing about a trust is we can retitle these assets. We retitle the distribution, but we also have to retitle the assets so it's no longer in the name of just the estate holder. So the title on an asset, whether it's a corporate piece of stock, whether it's a piece of real estate, whether it's a bank account, a car title, whatever it is, we don't want it to just say John Doe or Mary Doe or John and Mary Doe. We want it to say the John Doe Trust by John Doe Trustee. And because the trust owns it, when John Doe dies, the trust continues that ownership. It does not have to go through any title change or any court process. And that continues on and will transfer title, that document, that trust will transfer title by itself to those surviving heirs based upon the terms and conditions that are described in that document. So they're going to be able to take title without having to go through the probate process. And you can see on our slides we've got those bullet points pointed out.